My name is Øyvind Ravna. I'm a professor at law at the Arctic University of Norway, far north up in Tromsø. And I'm also one of the Entan representatives from Norway. And this presentation is about Article 27 of the International Convention of Civil and Political Rights. And it is probably the most important provision protecting the rights of ethnic minorities and indigenous people, including the indigenous Sami in Norway, to enjoy their culture. Included in the culture is also the rights to use the basis for the culture, the land and the natural resources. And this is about what the case is about, which I'm going to present. The Sami in Norway, which is a part of this court case I'm going to speak about, they are both an ethnic and linguistic minority and also an indigenous people in Norway and in Scandinavia, including Finland, Sweden, and Kola Peninsula of Russia. And reindeer husbandry is an important, not a huge livelihood, but a very important one because it's a culture-specific livelihood. The ICCPR, in its way, became a part of Norwegian law in 1999 when it was incorporated with the precedence for other Norwegian law. But it had not had any particular legal significance in the courts before in October 2021, when the Supreme Court of Norway, in a Grand Chamber decision, unanimously ruled that Norway's obligation under Article 27 was violated. The violation consisted in that Norway Energy Directorate have granted a license to build 2 wind power plants in the area of 2 Sami reindeer herder units in the middle Norway. As some of you probably know, most of the Samis live in the northern part of Norway, but there is also reindeer herders in the middle Norway. And they are probably the most vulnerable of the Sami, and they was affected hugely by this power plant. Together with the energy company, the Ministry of Petroleum and Energy was assistant in the court. The judgment, known as the Fosen case, really shocked the Norwegian government and the energy companies, which supposed they had found a good way to include the green shift in Norway. And it's also unique as sorry, things is working a little bit slower than usually this way. The case is unique as it's the first time the Supreme Court has concluded that an interference in land violates Article 27. The historic judgment is a result not of a test of the significance of the international law, but of an appeal against a case of determination expropriation compensation for the Sami. Usually when the state or energy companies build wind power plants, the reindeer herders is giving amount of money and then the case is solved. But in this case they contested the legality of the whole case, and therefore it go all the way to the Supreme Court. And the case started in 2010 when Directorate of Energy give license for building the power plant. It is possible to appeal this to the Ministry of Oil and Petroleum, and they also granted it. So after that, there is a long historical process before the case finally come up in Supreme Court in 2021. And in the meantime, the huge wind power plant was built because the Norwegian legislation on so-called pre-accession allowed start building only the energy company can guarantee for the compensation to the people, the persons or the groups who is affected. The main question for the Supreme Court of Norway had to decide on was thus whether the appraisal case for measuring of damages had to be denied as a result of an invalid license to build the power plant. In practice, it was a question if the power plant was legally or in frame with both Norwegian constitution and international law. And usually such cases used to have huge support for the state, also from the courts. In this case, a key question was whether the courts would be able to recognize that Sami society at large could be protected in the courts. The reason for this was not only that the Sami Sidas had defended the grazing land in vain in all the levels of court in this case, but also that there have been a long series of cases in the Supreme Court where the Sami has lost. A particular case was for another wind power plant where the Sami tried to stop the development before the legally was finally tested, which ended up with a bill to the alternatives of the energy company for Norwegian krone 1.77 million, which means 170,000 euros approximately for 4 days in the court. After that, they didn't dare to bring the case further. And this is probably familiar for you, the Article 27 of the ICCPR. The ICCPR in general aims to secure fundamental civil and political rights such as freedom of speech, personal security and equality for the law. In addition, it has this particular protection for ethnic minorities. Saying that such minorities shall not be denied the right in community with the other members of the group to enjoy their own culture, to profess and practice their own religion or to use their own language. And the interesting case here is that culture is interpreted in a wide way by the Human Rights Committee, which is the monitoring body for the convention. There have been several cases by the Human Rights Committee assessing interference in land for minorities and indigenous people. There are several cases from Finland, all of them known as the Landsman cases. The most interesting case here is the Poma case from Peru, where a group of the Aymara people in the Andes mountain lost their possibilities completely to exercise their farming or husbandry with their llama and alpaca animals. And from that case, we can learn two norms, which I will present for you now. The committee established that the legality of the measures which substantially compromise or interfere with the culturally significant economic activities of minorities or indigenous communities depend on whether the members of the community in question have had the opportunity to I'm sorry, there was things should happen here, but I just go on. Opportunity to participate in the decision-making process. This is the one criteria, and the other whether they will continue to benefit from their traditional economy. If the interference is that huge that they don't have economy outcome from the traditional economy, there is a violation of the Article 27. And in addition to the individual complaint cases, which I mentioned here, it can also be referred to the general comments where the Human Rights Committee interpret Article 27. And there we should particularly emphasize that the committee states, culture manifests itself in many forms, including a particular way of life associated with the use of land and resources, especially in the case of indigenous people. The reason that they particularly emphasize indigenous people here, it's I think is lie in the definition of the indigenous people, that they have a long-term connection to the land, longer than the current established state on the land. I have already mentioned a little bit about the place of the convention in the Norwegian law, but it is on a so-called semi-constitutional level. It's a higher legal rank than ordinary laws, but it's only the constitution who is higher than it. So it's stand in front of the Ordinary Expropriation Act. And also it has to be seen in connection with Article 108 of the Constitution. So to Norway, it means that even if an interference is undoubtedly for more benefit than damage for the society at large, it will not be legal if it violates the right of ethnic, religious, or linguistic minorities. It doesn't matter how much money they get in compensation for that. The Article 27 have been appealed for the Supreme Court in a significant number of cases in Norway, but it have not, the minorities have not been lucky to win these cases. Not before the Fosen case. So now I will go into the core of this case, why it's important, and I think also it can have significance outside Norway, at least in the other Scandinavian countries, but also other places where ethnic minorities have close relation to the land and fight against interference. The Fosen case concerns an industrial interference that can be compared with the Poma case, but without being the same extensive. The question at stake is whether the interference violates the rights of two reindeer herder units to practice their culture or to exercise reindeer husbandry. Article 27 sets up a threshold for the government to establish such power plant in their area. In order to decide whether the threshold for violation lies, the Supreme Court applies the aforementioned POMA case. In other words, the case law from the Human Rights Committee. Having pointed out that the violation appears where interference have a substantive negative impact on the cultural enjoyment, the court pronounces. Against this backdrop, my conclusion is that there will be a violation of the rights in Article 27 if the interference have a substantive negative impact. So that is the first standard. Furthermore, the court states that interference does not have to be the same serious as in the POMA case. And also important, the Supreme Court does not emphasize the consequences of the interference in question only. To determine whether there is a violation, the interference must be in connection with previous interference and also with future plans in an area. In practice, the threshold is passed when the members of a minority no longer is guaranteed an economical outcome of their trade. Yes, this, I'm sorry, this should have appeared before. But now I go to the main things there. The economy of the husbandry is therefore relevant in the discussion of a possible violation. The relevance must be assessed specifically in each individual case and must depend, among other things, on how the economy affects the cultural practice. In my view, the right in Article 27 are in any case violated if a reduction of the pasture deprives the owners of the possibility to carry on a practice that may naturally be characterized as a trade. So this is the statement of the Supreme Court. In addition, the court also emphasized consultation, but conclude that consultation is important, but in any case, just a factor that is a part of the assessment of whether there have been a violation, but not decisive for whether there is a violation. If the consequences of the interference are sufficiently serious, a consultation does not prevent violation. So this means that there is not possible to consult or to negotiation away from an interference. It also means that to put more money on the table for the indigenous people will save the legality. Another important things which come out of the case is that there is no proportionality assessment. You cannot start to weight the importance for the society at large against the interference in the rights of the indigenous people. After that, the court come to a conclusion that there is a violation, but remedy measures can solve it. But in this case, the remedy measures have to be cultural sensitive, and that was not the case in this case. So I'm on the way to summing up now, just the norms, what we can learn from the case. In addition to the size of the interference, the Supreme Court emphasized 4 factors in the assessment of the violation of Article 27. The first is the cumulative effect of the interference. If it's an area with a lot of infrastructure from before, there is should be less before the threshold is passed. The Supreme Court also assesses the extent to which the consultation have influenced on the decision, but it is not decisive if the interference is huge enough. And this also means that the concept of free, prior, and informed consent will not help if there is an interference big enough. And this can be seen in the eyes for the future generation. You should not trade away your land, which the future generation of your people will need. And the threshold particularly lies on the level whether the minorities still have economical benefit from the traditional trade. If it's not the case, there is a violation. Only if you have a mitigation measure that can solve the situation, the case can still be lawful. But that kind of mitigation must be adapted to the culture of, in this case, the Sami reindeer husbandry. Also, the Supreme Court clarified that there is no room for proportionate assessment. When we come to the end, what is interesting here? First of all, that this case, it's a national law case. But in any case, it's based on the Human Rights Committee's implementation, which means that it should have interest also for minorities outside Norway and probably also outside Scandinavia. And at last, how does the Norwegian government react on the case? Instead of closing down the unlawful power plants, the government considering further remedy mitigation. I will not go into that discussion as it's outside the scope of analysis of law, but at the same time it's difficult to imagine that the wind turbines can continue to roll at least to a significant extent without questioning being asked about Norway's ability and willingness to safeguard the material basis of the culture of the country's indigenous people. And not at least for Norway's compliance with obligation under international law and with national court decision. For in this case, the government have not followed up the Supreme Court decision so far. So yeah, this was what I had, so thanks for the attention.